Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please.
Good morning, counsel.
Case number 20.
Excuse me.
Case number 20-1370. Advocates for Highway and Auto Safety et al. Petitioners versus Federal Motor Carrier Safety Administration et al. Ms. Rosenbaum for the petitioners, Mr. Springer for the respondents, Mr. Callen for the intervener.
Good morning, and advocates for Highway and Auto Safety, counsel for petitioners may proceed.
Thank you. May it please the court, Gina Rosenbaum on behalf of petitioners. The hours of service rules governing the amount commercial motor vehicle drivers may work affect safety on America's roads and the health of the drivers. In the final rule at issue in this case, the Federal Motor Carrier Safety Administration changed those rules in two important ways. It expanded the permissible work days and driving radius of certain short-haul drivers. So those are drivers that are exempt from having to log their driving time because they stay within a certain circumscribed area and return to their work location and are freed from work within a certain set time. And it eliminated the requirement that long-haul workers take a 30-minute off-duty break if they have not taken such a break in the previous 8 hours of working, and replaced it instead with a requirement that they take only a 30-minute break from driving if they have not taken such a break from driving in the previous 8 hours of driving. Neither of these sets of changes were the result of reasoned decision-making. The agency stated that it did not expect the final rule to have negative impacts on either safety or driver health, but did not provide reasoned explanations of those conclusions in light of the evidence before the agency in the administrative record. Starting with the short-haul exemption, a 2011 study sponsored by the FMCSA, the Blanco study, found that driving later in the workday has a negative safety effect. By expanding short-haul drivers' workdays from 12 to 14 hours, the final rule allows driving later in the workday and would therefore also be expected to logically to negatively impact safety. But despite
it also conforms the rule for short-haul truck drivers to the rules that had always, as I understand it, had always been in place for the long-haul drivers, the 11-14 limits, and also the rules that had governed short and long-haul cement mixer drivers. So isn't that at least pretty significant fact in framing whether this seems like the kind of change that's likely to be dangerous?
Well, it does make the short-haul workdays the same as the driving window for long-haul drivers. But absent evidence in the record that the long-haul drivers drive just as safely with a 14-hour driving window as they would with a 12-hour driving window, that doesn't indicate that expanding short-haul drivers' workdays will not affect safety, particularly, and there isn't evidence of that in the record about whether drivers, long-haul drivers drive just as safely with 14 hours as they would with 12 hours. And in fact, the Blanco study indicates just the opposite. It found that when drivers drove further into their 14-hour workday, that there was a negative safety implication from that. With regard to the concrete mixers, the ready-mix concrete mixers, the agency did do some analyses of crashes involving those concrete mixers in the 2 years before and after Congress extended their workdays, the workdays of short-haul concrete mixers. But as commenters noted, there were many limitations with the analyses. One is that it didn't just look at short-haul concrete mixers. So it wasn't just a study of the drivers whose workdays were extended in 2015.
You have Blanco and you have Tio. They have concrete mixer. None of them is perfect, but the agency is picking among different studies that are cutting in opposite directions. It's a pretty granular level for us to come in and second guess them.
Well, even when there are different studies, the agency has to provide a reasoned explanation for reaching the conclusion that it does and for relying on one set of studies as opposed to the other, and for why it didn't think that the studies showing a negative impact on safety were worth relying on. And here what the agency stated, despite the Blanco study and the TO study, was that it had no reason to think that the changes to the short haul exemption would have a negative impact on safety, which is not reasoned. Although there are these concrete mixer analyses, it does not justify the agency's statement that there's no reason to think that there would be a negative effect on safety given the Blanco study and the TO study. And I would note that the concrete mixer analyses, also commenters had noted that there are reasons to think that concrete mixers would not be similar to other short haul drivers, that they may drive more slowly or spend more time on highways. And what the concrete mixer analyses actually showed was that crashes of ready-mix concrete mixers increased 8.5% in the 2 years after Congress extended short haul concrete mixers workdays, as opposed to the 2 years beforehand. And the agency nonetheless relies on those analyses by saying that concrete mixers' share of total truck crashes did not increase in a statistically significant manner during that time, but doesn't provide the information that would allow anyone to know whether the share of concrete mixers, the percentage of concrete mixers themselves involved in accidents, increased in a statistically significant way over that period. And there was, whether that 8.5 increase was statistically significant when considered as a share of all ready-mix concrete vehicles, as opposed to as a share of all truck crashes. Related to safety, the agency also did not reasonably explain its conclusion that expanding the short haul drivers' workdays and driving radius would not affect compliance with the hours of service rules. The hours of service rules, in addition to setting limits on workdays.
How does the radius, put aside the hours right now, how does the radius affect compliance?
It affects compliance by working in conjunction with the extension in the workday, in that it allows drivers to
No, but you
drive.
don't have any independent, you're joining it up with the hours extension. I'm asking if you have any independent basis for thinking that just as the radius, I'm trying to divide these two things up, that itself has an impact on compliance.
Well, the way that it would have an impact on compliance is that it allows drivers to drive longer distances without stopping. So
How do we know it's without stopping? How do we know that they're not stopping just as they do in shorter distances because they're short haul and maybe they're just able to reach a few more customers? We don't know that they're only going to one more customer in that additional radius area, whatever it's called.
Well, when the Federal Highway Administration adopted, in 1980, the Federal Highway Administration extended the short haul workers' workdays, the driving radius from 50 to 100 hours. And when it did that, it adopted the 12-hour limitation, saying that in light of the larger area, it thought that the limitation on hours was necessary to ensure that the hours of service are not violated. So
again, we're talking about a limitation on hours there, and I'm still trying to talk. I don't understand how the radius, I don't understand your concerns about the increase in radius. It just may deal with placements and routes that allow companies to reorganize, or in their view, I assume, more efficiently organize routes to meet a greater area. But I just don't see compliance or honestly even safety concerns about the radius itself.
Sure, with the radius allowing them to go further does allow them to go more without stops. And it may be that some of them still do as many stops.
How do you know they're going more without stops as opposed to they've got, wow, great, I can meet this other circle of customers and I'm going to stop every 10 miles or 15 miles. There's 2 more customers, I'll stop every 15 miles.
So they may do that, or they may decide that they're going to go further, have the same number of stops.
That's the point, we don't know. Well,
have the same number. And the agency at one point says that
they could do that within the shorter radius as well. It just depends on how companies organize their routes, doesn't it?
Right, but they can now organize their routes so that they go farther out and have less distance between stops, which would then allow
It's that second part. I'm sorry, I'm repeating myself. I get that they can go further out. I just don't know what evidence in the record is there that when you go further out, there will necessarily be less distance between stops as opposed to maybe it'll be roughly the same because they've got more customers out there.
Right. So it's not necessarily, we're not saying that in every instance they will have fewer stops.
Most instances. Do you have evidence of most instances?
It does allow them to go.
Oh, you could have said the same thing from 50 to 100, but.
And the agency did recognize with the change from 50 to 100 that because it did allow them to go further, that there then needed to be other limitations to keep them, that affected compliance with the hours.
That's where we're back to the hours issue, but.
Right, well, they do work hand in hand. So it realized that without limiting hours, that the extension in the air mile radius would allow more violations, showing that.
Would your challenge to the hours change be any different if they had left the travel radius the same?
We would still have a challenge to the hours if they had left.
Would it change in any way? I assume you'd be making the same arguments.
Exacerbates. I do think that the change in the air mile radius exacerbates the change in the hours because it does allow them to go a greater distance without stopping if they want to, although they won't do it in every time. And the final rule at one point does acknowledge that they could potentially go further with making fewer stops, or that the change in the hours could also allow them to make more stops within a smaller radius. But in 1980, the Federal Highway Administration did acknowledge when it expanded the air mile radius from 50 to 100 miles that a limitation on the hours was necessary in order help ensure that the hours of service were not violated. And then again, in 1987, it reiterated that it thought that 12-hour limitation was necessary to ensure that drivers were not violating the hours of service without detection. The agency has not explained, sorry.
Please go ahead.
The agency has not explained why, if the 12-hour limitation was necessary with a 100 air mile radius, why it would not be necessary with a 150 air mile radius, or in any other way explained what has changed since 1980 and 1987 that makes the rationale that underlay the prior rule no longer still apply today.
If you prevail, this is just a if question, on your hours challenge, and they were to be vacated, what would the radius requirement have to be vacated, or could that stand?
I do think that these were changes that were enacted together and go together, and the agency did not really separate
lots
out.
of things are enacted together, but we don't think they have to get vacated. I'm not sure that's our test.
I do think
it would be simpler if it were.
I do think that they were sort of part and parcel of the same change. And
I don't know what you mean by part and parcel. They did them. That's another way of saying they did them at the same time. But the agency can tell us their views on this as well. But given that the arguments seem to keep coming back to the hours limitations, and that's what's needed to ensure for your compliance argument, then if they had kept the same hours requirement but just increased driving radius, I don't know what your objection would be, because you would still have the 12-hour, which you say is the backstop needed for compliance.
Right. I do think that would still have the possibility to affect compliance the same way that a change from 50 to 100 air miles, the agency recognized that could affect.
Yes, and it said the backstop to that was 12 miles. And if you had, your druthers, then there was the 12 hour requirement. If that were to stay in place, you say that protection wouldn't work if the radius were increased? What evidence in the record shows did the agency not grapple with, or what rationale is given that if there were if the 12-hour limitation were maintained, it wouldn't work once you go from 100 to 150 on the travel radius?
I mean, we do think that the same way that switching from 50 to 100 has a possibility to affect compliance. So
you're just saying any change creates enough of a compliance problem?
I do think that it does present a compliance problem, but the extension of the 12 hours to 14 hours certainly gives many more opportunities not to comply for drivers to be able to violate the hours of service limits or to be pressured by employers to violate the hours of service limits without detection. And the agency hasn't explained why the rationale underlying that 12-hour limitation is no longer applies. I do want to briefly touch on the 30-minute break requirement. And in particular, the agency is required to consider health when it's making changes to the hours of service rules. And here there is no indication or analysis of the effects of the 30-minute break requirement on driver health. The agency only broadly talks about how it does not expect the final rules changes overall to negatively impact health, with no analysis specifically of the 30-minute break requirement. And this is particularly problematic given that the rule that adopted the 30-minute break requirement in 2011 did find that there would be health benefits of $94 million to the 30-minute break requirement that were based on a connection between reduced duty hours and morbidity, so would seem to be affected by these changes in the final rule.
So what's the health concern other than impact on crash likelihood?
So the health concern would be a health concern about working
Just
more.
working 14-hour days is stressful.
And I assume it would be the particular health risks associated with sitting and driving for 14 hours.
Well, health risk,
The drivers have or not distinct health risks, but higher percentages of certain diseases. At least this is what I heard the record said. And if they already have that at 12, or if they already have that without the 30-minute break, would it not be worse? Or is that
so I think it would be the health risk of both working,
Right.
of sitting for so long and having these long days combined with not having the right to an off-duty
downtime?
But the agency did not analyze the break at all or there's no indication that it analyzed the effect of the break on health impacts.
The break or breaks, the concern is you're sitting, could be sitting for 8 hours in a row, and that has cardiovascular effects or whatever. The break, that's a concern from sitting too long and not from working too long, right? And the amended rule addresses that because it's keyed to hours of driving.
So the amended rule does address sort of sitting continuously.
Right.
But the health benefits in the 2011 regulatory impact analysis were actually based on increases in duty hours overall and connections between increased working time and morbidity.
Right. I'm just trying to separate out the idea that I had in my mind was long work day. And the different idea that Judge Millett pointed out was the concern from sitting too long. Those seem to me different.
So I think those are slightly different. The new rule may somewhat deal with the sitting too long.
The new rule does deal with the sitting too long, I think.
In some ways, although it also does only require the break to be taken after 8 hours of driving as opposed to 8 hours of working. So if someone has done work earlier on in their duty period, that would still allow them to be sitting longer before they take the break. Because
what's the typical non-driving work? Is it likely to be sedentary, sitting at a desk, filling out forms, or is it likely to be active, loading the truck or whatever?
I think both can be done. There can be loading time. There can be time just sort of sitting around waiting. There could be time doing paperwork. So I think both are possibilities.
Okay.
I see that my time is up. So thank you.
Good morning, Your Honors, and may it please the Court. Brian Springer on behalf of the federal government. I'd like to start by focusing on the specific changes that FMCSA made to the hours of service rules. The short haul exception does not extend driving time, but instead changes the reporting status of drivers who travel between 100 and 150 miles of their reporting location, and who return to that location between 12 hours and 14 hours from the start of their shift. The 30-minute break requirement also does not change the driving limit, but instead requires that long-haul drivers take a 30-minute driving break after 8 hours of driving. These changes are reasonably explained and supported. Nothing more is required to uphold the agency's considered judgment. I guess I'd just like to...
At least on the, I don't mean to go backwards, but on the 30-minute break issue, if someone's day is sort of front-loaded with non-driving activities, and then for 6 hours, and then they drive 8 hours, and that's the end of the 14-hour day, there will be zero break within 14 hours. Is that right?
Your Honor, the agency
That's
found...
right? There'll be zero break, zero rest break. There, I guess you would call the first 6 hours of non-driving work a break.
Your Honor, the rule wouldn't require a break in that circumstance, but the agency found that drivers are likely to take breaks when they need rest anyway, that drivers are often stopping to eat food and to use the bathroom, and that when they need time to rest and to take a break, that they will do so in any event. So the rule just doesn't require...
Self-regulation is what the agency is now relying on.
Your Honor, the agency also
Did
considered...
the agency find that they don't eat while driving? Maybe they grab their food, but I mean, it just...
Your Honor,
It seems odd to me to say they can work an 18-hour day straight through and have, I'm sorry, not 18, 14-hour day straight through with no downtime break, solid work for 14 hours. And maybe they run in and out of a restroom. And that's it. And that is what deemed to be consistent with making safety a highest priority?
Honor, so the agency considered the Blanco study here and found that what the Blanco study explained is that any break from the driving task is what creates a benefit to the driver. So the agency explained that, looking at specifically the fact that drivers might stop for fuel or stand around while their truck is being loaded or unloaded, and that those breaks from the driving task are exactly what provides the safety benefit.
Though none of those are required. You're just hoping that they happen. You're expecting that they'll happen. It's more than hope, to be fair.
Well, Your Honor,
they're not required.
They do have to happen if the driver has driven for 8 hours or more.
No, but under my theory, where the 6 hours is work up, the on-duty work 6 hours up front, and then there's 8 hours of driving at the end of the day, which is the worst time studies have revealed for driving concerns and risks. Later in the shift, later in the day, the higher the risk goes. But that 8 hours would be without anything unless probably they have to stop for gas. Maybe they grab some food to eat while driving. And that was found to be consistent with making safety a highest priority. How?
Your Honor, I think that what the agency said here was that based on the comments it received, that sort of situation wouldn't happen often. It wasn't realistic, because drivers will take breaks regardless of whether they're mandated to take an
How long are those breaks? What did the agency find? How long does the gas break take? And the gassing up, presumably, maybe the bathroom, that one happens at the same time, maybe food, maybe they do it all at once. How long a break are those things? Put aside the on-duty, non-driving, break from driving by on-duty work. Did the agency find how long those are?
Your Honor, the agency couldn't make that finding because it varies from circumstance to circumstance and depends on exactly.
Doesn't that matter a lot, though? It doesn't have to find precisely, everybody does exactly 10.3 minutes. But isn't there some need for some substantiation that this is actually a meaningful period? Because just saying they're not driving without knowing for how long they're not driving, and particularly if you're talking about late in the shift, why doesn't the agency need to have something under a statute that says make safety your highest priority? You need something more than sort of anecdotally, people take time to get gas, go to the bathroom and grab some food.
I don't think it's just those anecdotal pieces of evidence. It's also the Blanco study, which, as I mentioned, the agency considered and explained that what the Blanco study says is, as well as multiple other studies describing the Blanco study and its findings. But what those say is that what provides the benefit, and combats the effects of fatigue at the end of the day, which is what we're really concerned about here, is the break from the driving task, which under this rule, drivers are required.
But didn't the studies also say that as they get later into the shift, risks increase?
Your Honor, it does say that, but
And if you had 8 hours straight of driving.
Again, Your Honor, the agency explained that that just was not likely to happen.
No, but it didn't find how much. How can we know that I'm running to the bathroom and grabbing a sandwich while my truck is gassing up? And then I'm right back in there because deadlines are deadlines. That doesn't the agency need to focus on? You can say they're going to do that, but whether that is physically and mentally a meaningful break?
Your Honor, I think that the agency has that support from the studies that it cited, including the Blanco study and I believe it's called the Sokolish study, among others, that this is the way. And when you combine that with this anecdotal evidence.
But they had done that. Those studies, I assume, were done at a time when they were also getting a 30-minute break after 8 hours of work, whether it was driving or non-driving. Were all those studies and experiences occurring at a time when they were already under the prior rule getting the 30-minute break from work?
Your Honor, the Blanco study was done before the 2011 rule. And the Blanco study specifically talks about non-driving versus driving breaks and says that a non-driving break can provide, at least the agency explained that its analysis of Blanco is that study says.
Did Blanco say that?
Yes, Your Honor, it did.
Okay, because you quickly corrected to the agency says that's what Blanco said.
Well, Your Honor,
Blanco said that.
Well, Your Honor, obviously we should be focusing on the agency's analysis of Blanco, but that's also explicit in Blanco itself. For example, at JA 25, it says that non-driving breaks are just as beneficial or can be just as beneficial as these off-duty breaks.
Well, but in 2011, the agency found that off-duty breaks provide the greatest benefit. You don't disagree with that?
Your Honor,
which is very different from it's just the same to have an on-duty break. It sounds inconsistent.
Your Honor, the agency made that finding based on the Blanco study, which it reanalyzed in issuing this rule and determined that it had placed too great a weight on the benefits of off-duty breaks, and looking at Blanco again and particularly analyzing it in the context of the particular.
It was wrong when it said in 2011 that off-duty breaks provide the greatest benefit. That was wrong.
Your Honor, the agency has decided that it reads the Blanco study differently now that it.
So it was wrong. It read it wrong in 2011?
Your Honor, based on the experience that it's had in between, it has changed its analysis of what.
Of the study? The study, you can say they're relying on experience, but they read the study one way in 2011, and now they're reading it a different way. So one of the two has to be wrong.
Your Honor, they're reading it in a different way.
Or else the study isn't worth much if you can't really tell that much from it.
Your Honor, the agency's reading it differently in part because of the way that Blanco characterized what counts as an off-duty versus on-duty break. So the agency was actually looking at in the real world how these things work and which classification those things would fall under based on the real hours of service rules. And based on those classifications, it determined that it had placed too great a weight on the benefits of an off-duty break when a driving break is really what provides the benefit.
And there's a driving break of any length of time, to be clear, right?
Your Honor, it's required to be a 30-minute break if the driver has been driving for 8 hours.
Right. I've got my 6 hour and 8 hour hypothetical. A break of any time is equivalent to a 30-minute off-duty break. That's the agency's conclusion here.
Your Honor, again, in that circumstance, the agency said that drivers would likely take breaks.
A break of any time, those breaks that are not quantified on time. A break of any time. That's the agency's reading of the Blanco study, informed by its experience, that after working 6 hours in the office or loading or whatever they're doing, and then driving they've got an 8 solid hours of driving ahead of them, a break of any time. Yes. I mean, I think yes, that's got to be your answer. That's what the rule says.
Your Honor, what the agency says is that Blanco shows that there's not, that this distinction that the agency itself had drawn between on-duty and off-duty breaks was not supported by Blanco, and instead that the on-duty break is really what provides the benefit to the drivers in terms of combating fatigue. And obviously, the agency didn't have perfect evidence, but it looked at what it had. It made judgment calls about the dueling studies and about the information that it received from commenters and reached a reasonable conclusion based on, within the limits of the data that it had.
There's something a little bit odd about the agency's justification in the following sense. I mean, it seems very obvious that at some point, drivers will need breaks, right? They drive for too long, so there starts to be a safety risk. And it seems pretty plausible to me anyway that you drive for 8 hours in a row, you're getting past that point. And the agency doesn't really dispute that as a proposition of how human beings fatigue after driving for 8 hours. They say, don't worry about that because no one's going to be driving for 8 hours, right? That's the basic rationale, which is to say that the standard the agency has set has no meaningful impact because nobody drives for 8 hours without a break of some kind.
I don't think that's exactly right in the sense that what this rule requires is that if somebody drives for 8 hours without taking a 30 minutes
Right.
continuous break, that in that circumstance they are required to. The agency obviously was allowed to consider and did consider here how this is likely to play out in the real world. And based on what the agency was seeing, it saw that in general, drivers are going to take breaks when they need to take breaks and get rest, but that once they reach an 8 hours of driving time, they should be taking a break from the driving task because that's what provides the actual benefit of combating fatigue in these drivers as they continue to sit and drive for a long time. That breaking up that time on task.
Right, but they don't say, as a general matter, perfectly safe enough to drive for 8 hours in a row with no break. And then that's the point at which safety kicks in. They say most people won't drive for 8 hours without a break.
Your Honor, I think they say that, and they also say that that's also the time within which they expect drivers to take a break in order to combat this fatigue. I mean, the rule before was just about was also an 8 hour period. It was just an 8 hour on-duty period instead of an 8 hour driving.
No, I know, I'm focused on driving. I mean, you'd be making exactly the same argument if it were a 16-hour driving rule, right? You'd say, well, that's crazy. Don't worry about that because no one is going to be driving 16 hours in a row.
Your Honor, I'm not sure if that's true because potentially in that circumstance, drivers wouldn't have supported the rule. Here, multiple drivers came forward and supported the rule. This provides them greater flexibility and makes it easier for them to get home earlier and has multiple benefits for them. I suppose if it were a different calibration of the rule, it's possible drivers or employers would have come in and suggested that they were going to force their drivers to drive that many hours without a break. Here, we don't have that evidence.
They're relying on the gas, food, and bathroom breaks. Was the agency assuming those were 3 separate breaks or done simultaneously? What was the evidence?
All right, what were the breaks?
I thought the ones that were referenced in the rule were restroom, gassing up, and grabbing food.
There's multiple other breaks that the agency noted in addition to those. So there's using the restroom, getting something to eat.
So those are the 3 I said.
Yeah, the 3 you said. In addition to those, there's also waiting for the truck to be loaded or unloaded.
No, that goes to the driving on-duty time. I'm talking about my solid 8 hours of driving. What is there other than the three I've mentioned?
Your Honor, I suppose those are
That's probably it.
Right now, I can't think of
Right.
another thing that they're likely to.
I'm not a driver, but I don't know either. Right. And is the agency, when it says it'll be taking breaks, plural, it's assuming that drivers aren't efficient enough to do those three things at the same time? Doing in 3 seconds? Or is it assuming that those things are done simultaneously? So they're really in 8 hours, it's probably just one break.
Your Honor, I don't think the agency is assuming anything one way or another.
Did it
It's
find
just
anything
saying-
about frequent? I was talking to you before about the time, how long this is, but it did make any finding at all about how frequent these, they're not going to do it, breaks, they're not going to drive 8 solid hours, breaks are going to happen? Any evidence on frequency?
Your Honor, the agency didn't have specific evidence about that. It doesn't necessarily have the ability to get that kind of granular of information. However,
Why? It's got truckers telling them what you just told us. It had truckers telling of how they work. I just don't, I'm still struggling with understanding how the agency knew this was going to be enough of a break if it didn't know how long or even how often. But it concluded that this was consistent with highest safety. Just laying out for you sort of the mental gap that I'm having trouble bridging here, but you may be able to explain it to me better.
Your Honor, I think the important thing is that the agency made a judgment that after 8 hours of driving, drivers need to take a 30-minute break from the driving task. The agency recognized that in addition, drivers would likely be taking these short breaks to go to the bathroom and to eat and to do these other things that, would.
So the agency agrees that 8 solid hours, if they didn't do that, would not be safe.
Your Honor,
its rule assumes that there's some break within that 8 hours.
Your Honor, I'm not sure that the rule assumes that. Again, it specifically said that this isn't likely to happen because drivers are taking a break or often taking a break from the driving task as a matter of practicality. Your Honors, I'm also happy to address the short.
I'm sorry, you should, if my colleagues want to talk about that, I'm sorry I took up too much time.
No, that's fine. Are we done on the break time? So on short haul, seems like the most plausible explanation for the expansion of the exemption would be to simply say you're conforming the basic rules. Basic rule is you can drive 11 hours within a 14-hour shift. You're just conforming the rule for drivers subject to the short haul to drivers subject to the long haul and the cement mixers, and that's the baseline. No reason to think it isn't working, so you're harmonizing this group to that rule. But you didn't quite say that. You said that the changes were safety neutral. Seems to make an assertion about ex post versus ex ante, that not about safety relative to other groups, but that the changes would make things no less safe for the short haul drivers. And that's a tougher position for you to establish factually. So am I misreading the agency's rationale?
No, Your Honor. So the agency did note that it was conforming the short haul exception to a short haul exception that existed for drivers who don't have to have commercial driver's licenses, was also making some of these changes made it more consistent with the driving window for long haul drivers. But the agency, and again, of course, the agency didn't have perfect information here, and it used the available data that it had. I think one important piece of information that the agency had was this data about concrete mixers. And in particular, Congress extended their workday, at least those concrete mixers who use the short haul exception, extended their workday from 12 to 14 hours. And so the agency looked at the changes in crashes across the time that Congress made that change, what the agency saw is that particularly at the end of the day, when we would expect these drivers to be reaching the end of their shifts and most likely to have accumulated large levels of fatigue.
I understand you have both strands of reasoning, but in order to uphold this rule, would we have to conclude that there is substantial evidence for the proposition that the amended rule is no less safe for the short haul drivers than the pre-amendment rule?
Your Honor, the agency's final conclusion was that this change to the short haul exception was not likely to have an adverse safety
I understand,
impact.
but is that essential? Is that an essential element for us to uphold?
Your Honor, I think that was the agency's rationale, but it had multiple pieces of evidence here to support what its conclusion was, that these changes were not likely to have an adverse safety impact.
If you're resting on that theory, you didn't talk about Blanco on this point. Seems like a pretty glaring omission. If your theory is this makes things no less safe. Agency's own study, it's only one and they're competing studies, but it's the agency's own study. It's a study that you relied on very heavily on the break point, and you don't even mention it on this question. Why isn't that arbitrary?
Your Honor, the agency did discuss Blanco within the context of the short haul exception, and it noted specifically that what Blanco shows is that taking breaks, are helpful to combat fatigue at the end of the day. The agency explained that short haul drivers, short haul operations by their nature are limited because the short haul drivers are making frequent stops throughout the day. They're getting out to drop off cargo, to talk to customers. That's sort of the nature of the business.
I thought you relied on Blanco for the break, the 30-minute break point, but not the short haul point. Did I miss something?
Your Honor, the agency relied on it for both.
Okay.
The agency in particular noted that, its discussion in the 30-minute break piece applied to its discussion of the short haul exception.
Did the agency find with its concrete study that concrete drivers make the same type of frequent stops and have the same kind of loading and unloading responsibility, sort of the physical tasks of loading and unloading that any other short haul drivers do?
And my understanding is that the concrete mixers make multiple stops throughout the day and usually are standing around while the concrete is being unloaded.
There's obviously not loading or unloading. There's not boxes or anything to load or unload. So that physical exertion is not the same as many other short haul drivers. And when they say they make frequent stops, what I'm asking is sort of an equivalence. Are they representative of short haul drivers? Do they find that they're representative of short haul drivers? And I could be wrong, but I think of like a Amazon driver or a UPS driver. They're just stopping all the time. And I guess I would have thought concrete ones would go to a construction site and stay there for a while and maybe later go to another construction site.
Your Honor, the agency noted that the concrete mixer data wasn't perfectly representative of all short haul operations.
But it found it to be representative.
It did find it to be helpful here, and it was the best
Can it be
available.
helpful if it's not representative?
Your Honor,
You said not perfectly representative. Did they find that it was representative?
Your Honor, they found that this evidence was helpful to think about what the likely change.
How is it helpful if it's not representative?
Your Honor, all they said was that it wasn't perfectly representative. They didn't say that it didn't have any probative value.
They didn't say that it did, that it was representative. Isn't that a problem?
Your Honor,
There are lots of things that aren't perfectly representative that in fact are not representative at all. Didn't they need to find, or tell me why they didn't need to find that it was representative as to these things, as to the activities that short haul drivers engage in, the physicality of their activities during stops, and the number of stops per day. Which seems to be sort of the critical ones for, maybe there's another one you're aware of, but those seem to be sort of the critical ones for
Your Honor-
understanding the physical impact of the day.
Your Honor, the agency was considering the concrete mixer data within thinking about what the fatigue effects would be of this rule. And the agency explained that this was the best available data because it was nationwide and it showed how it allowed the agency to do a before and after comparison.
But if it's not representative, how can it be? I mean, best available could be still entirely non-representative. It just could be best available, but not good enough. It doesn't seem to me it's enough to say this is the only study we could find. Make safety conclusions without saying they're not identical, but they are representative enough. That it allows us for safety purposes to make this, that it involves equivalent or closely equivalent exertion, nature of on-duty, non-driving activities. Don't they need to do that? Or can they just say it's the only study we could find? That's not really relevant at all, but it's the only one we have. It's not perfect, but we're going to rely on it.
Your Honor, the concrete mixer data was also consistent with the agency's analysis of the Blanco study, which suggested that taking these breaks throughout the day was likely to combat fatigue at the end of the day. And therefore, the agency considered all of these pieces of evidence together.
Did Blanco say it doesn't matter how much exertion is involved during those days?
Your Honor,
for a study for a still working but non-driving break, does the amount of exertion, the amount of physical exertion involved matter?
Your Honor, so the agency explained that Blanco says that taking a break from the driving task is what's producing this.
But
risk,
what kind of breaks was Blanco thinking about?
Your Honor, the Blanco involves a number of different types of breaks, some that include rest with work and some that just include on-duty work,
like
some that are off-duty.
What kinds of on-duty work?
I don't remember the specifics, Your Honor, but it's similar to what the agency is discussing here. And looking at Blanco, the agency looking at Blanco in conjunction with the consistent concrete mixer data, which allowed this before and after comparison, the agency exercised its discretion in weighing the evidence here to reach its conclusion. Your Honors, if there are no further questions, we would ask that this court deny the petition for review. Thank you.
It please the court. My name is Paul D. Cullen Jr., and I represent the Owner-Operator Independent Drivers Association. This is a trade association of 150,000 small business truckers from across the country. In my limited time, I'd like to focus on the 30-minute rest break rule that's of particular interest to the members who are mostly long-haul drivers. FMCSA's rule was more than rationally based to deal with two negative safety consequences of the prior rule that was described in OOIDA's comments and its studies and the testimony of its drivers of the listening sessions that FMCSA held during the rulemaking. Those two negative consequences are, one, drivers are being forced to stop in unsafe locations to comply with the rule. And the second was the rule, because the rule extended the workday, causing more stress and pressure to complete their work, and that resulting shorter time later in the day. Now, why are drivers parking in unsafe places? There's a major problem with truck parking across the country. Although it's a 30-minute rule, it can take up to an hour or more to find a place to park. And therefore, it becomes a 60 or 90-minute break out of their day. But if they're unable to find truck parking, which is a frequent occurrence, then they will stop on the side of the road or on an exit ramp in order to not violate the rule, not be moving and violate the rest break provision. Taking 30, 60, 90 minutes out of a driver's schedule pressures them and and adds to their stress to work in the remaining part of the 14-hour day, pushing their work later in the day. And drivers have been observed speeding, driving unsafely, driving in rush hour traffic or conditions they would otherwise choose to wait out because their workday has been made shorter and they have to accomplish the same amount of work. The rule often requires in that first 8 hours drivers to stop when they're not tired. And because they stop when they're not tired, and it takes that 60 or 90 minutes out of their schedule, then they have less discretion to stop later in time when they are tired. This new rule is a little less one size fits all than the old rule, giving the driver the flexibility to make decisions to work when they can and rest when they need to. These were the truckers who kept the engine of our economy going for the last 2 years, and the rule recognizes the role of drivers to make decisions to operate more safely on the road.
Is it really a question of flexibility as opposed to a question of what is the more important safety trigger, the time driving or the time working? It's an 8-hour rule either way.
The time off from driving. So if a driver can comply with the rule, as Your Honor described, maybe they go to the restroom or get something to eat, they can extend, or other activities include tying down, making sure the load is tied down properly. There are drivers who use such equipment have to do that every 2 hours. They may be filling out paperwork.
All right, some people have to stop every 2 hours to check how loads are tied down. Is that what you just said?
Correct.
So they have to hunt for places to pull over and do that too.
Yes. And
Sounds like knowing where to pull over is part of the job, huh?
I'm sorry?
Sounds like knowing where to pull over in advance is probably part of the job.
Well, it certainly is, but there are many instances where drivers are sent where they've never been before. And there are many places where truck parking is at a great shortage. So even if you know, okay, I know there's a truck stop down the road, well, if it's full, then you're driving on a longer period of time to find a place to park, try to find a safe place. The negative consequences reported into the record by the client and its members are more absolutely justify in our rational basis to support the flexibility rule. Thank you. Thank you, Your Honor.
Just a few quick points. On the concrete mixer analysis, what the agency said about the concrete mixers is that FMCSA did not claim that the analysis is definitive or that the population of concrete mixers is representative of all short haul operations. That's on Joint Appendix 268. And to the extent that the analysis of the changes in the short haul exemption did mention the break aspect of the Blanco study, that was in discussing the 30-minute break requirement. So in addition to being exempt from logging their duty status, short haul drivers do not need to take the 30-minute break. And there was a discussion in the discussion of the short haul exemption about the fact that now drivers who drive between 12 and 14 hours or the longer radius will not need to take the 30-minute break. So in that context of discussing the 30-minute break and how the 30-minute break interacted with the changes to the short haul exemption, the agency did talk about the break part of the Blanco study. But just in justifying whether extending the workday of short haul drivers would have an effect on safety due to driving later in the workday, it did not justify that extension based on breaks. Finally, on the point on brakes, the agency did note that brakes.
You said brakes?
Sorry, on the 30-minute break requirement, the agency, in stating that it thought that drivers would continue to take breaks, did state that those breaks may be shorter than 15 minutes or involve non-driving work. And it also stated that it did not think that drivers who drove less than 8 hours would amass fatigue. So it was not depending on those drivers taking breaks. It just did not seem to consider that there was a fatigue element to driving up to 8 hours. And unless there's any further questions, we would ask you to vacate the short haul exemption and 30-minute break requirement changes in the final rule. Thank you.
So we will take that petition by petitioners under review and move on to the next case.
Case number 21-5219, Changji Esquel Textile Co. Limited et al., appellants versus Gina Raimondo, Secretary of Commerce et al. Mr. Tice for the appellants, Mr. Aguilar for the appellees.
May it please the court. All parties agree that under the Export Control Reform Act of 2018, Congress directed defendants to establish and maintain a specific list, the entity list, pursuant to the goal of addressing 5 extraordinarily serious national security and foreign policy threats. The question presented is whether the government can expand its entity list authority by means of a catch-all provision found in subsection 4813A16, and thus add entities for reasons beyond the 5 Congress selected. The answer is no. This court has held repeatedly, including in the 1995 decision in American Petroleum Institute, that an agency may not rely on its general authority when a specific statutory directive defines its relevant function in a particular area. That's exactly—
Even where Congress has directly ratified the agency's rulemaking during the interim period.
Well, Your Honor, I assume you're referring to section 4826A, and I don't think that is a case of ratification of any rule with respect to the grounds upon which my client, Changji Esquel, was listed.
To the extent it's saying that the agency had authority to issue those rules. Isn't that significant, given the statutory provision that I know you don't want to rely on because you say it's a catch-all under your canon of the specific trumps the general?
Well, Your Honor, just to be clear, the provision that carried forward all existing regulations did so only according to those regulations' terms. And at the time, there's no dispute about this, at the time of the Reform Act of 2018, no entities had been listed for human rights violations. And the specific regulation in question, I think it's 26 CFR 74411, does not list human rights as one of the grounds for adding entities to the entity list. It lists adding entities for national security and foreign policy threats. And traditionally, until essentially the Trump administration, the grounds for adding entities to the entity list were those same serious national security and foreign policy concerns: weapons of mass destruction, terrorism, weapons proliferation, and those sorts of things. Now, it is true.
Do you dispute that they could, that they have the authority to create another list under this statutory scheme they wanted to call this the human rights violations that impede foreign policy list, that they would have the statutory authority to do that. Do you dispute that?
I think they would likely have that authority, Your Honor.
How would you text? Why isn't it? You say likely, so what's your qualification?
Well, because
The statute doesn't say there's only one list allowed.
Well, correct. I would say that there is an argument, I think, under the expressio unius canon that the fact that the statute directs them to make a list pursuant to this purpose.
Yeah, but it only has 5 things, whereas I've got my numbers right, 4811 lists a lot of things, including human rights abuses.
Correct.
As something that is to be enforced by this statute. So I think that may likely kill off any expressio unius argument. It's meant to be enforced. There's references to this being enforced under the statute. And so if they could create another list, wouldn't be we're not going to put you on the same list as the 5 really, really bad things. I don't know how you compare these things. They seem incomparable. But if they have the human rights violations that impede foreign policy list, you have anything else that you have anything else to tell me that would say they can't do that under the statute?
Well, like I said, that's why I think they probably do have the authority.
Right.
Your Honor.
So
I don't think it suggests that what they've done here is legal.
Right, but if they have the authority to create the second list, then your ultra vires argument has to come down to is so clear under this statute that it has to be a separate. Could that separate list impose the exact same types of sanctions as the first list?
Again, probably.
Nothing is right. So it could do exactly the same thing. It's just called the human rights abusers list. I don't think anyone would want to be on that list given that title, but they'd have that. So it's going to have the exact same consequences, exact same operation for them, no other exact same impact on their business, and they'll be labeled a human rights abuser. X company will be labeled a human rights abuser and get on that list with very, very notorious entities. And so if that's true, if we take that as true, you don't seem to be pushing back that hard on it, then the ultra vires distinction would be they can't combine it into a single list. That's the question before us.
I don't think that's exactly right, Your Honor. And like I said, I think even if they have that authority, it does not actually suggest what they did here is legal for 2 reasons. One of them is even if, to take your hypothetical as it stands, obviously this is not what they did, but hypothetically, if they had made a list with the exact same legal consequences, that would not change the fact that there are significant and discrete special reputational and practical consequences that this list over a 25-year period has built up. This list was established in 1997.
I don't know. I'm not sure the reputational consequences would be meaningfully less if you're put on the list of human rights abusers. And let's say in company of X, Y, and Z country that's notorious for that. I suspect a company would be complaining just as much about reputational harm because you're on an export list, a red flag by the government. And so what in the statute, given the standard for an ultra vires challenge, makes clear that the problem here is they can't have one list.
Well, I think we're looking at what I think we're looking at the authority that Congress granted to the agencies, which are, of course, creatures of statute. And in this section, in very specific and clear language, said, establish and maintain this list pursuant to these 5 specific policies. So even if they did have the authority to create other lists, that would not change the fact that Congress did not grant them the authority to create a list pursuant to that directive that includes these other statutory commands. And I think it's important to think about the history.
What textually says that list must stop with those 5 things? I mean, it has to certainly include those 5 things. Those are required. Textually, what tells us the standard of ultra vires review that it can include nothing other. You have to start it different.
Well, I'm happy to give you, I'd like to talk about specific textual clues, I think, that show us. But first, if I can answer the question by saying that is the same situation as in the American Petroleum Institute case. this court held that the agency tried to argue that Congress's directive to follow a certain policy did not preclude them from following additional policies that were subordinate to that primary one. And the court said, Congress does not have to speak in thou shalt not terms in order to create an ambiguity. If Congress creates a clear and specific directive.
Was that an ultra vires review case?
That, Your Honor, was an APA case.
So I think the difficulty for you may be that to establish an ultra vires case, don't you have to point to a thou shalt not?
I don't think so, Your Honor. I don't think so. And I think that I can give you a few different examples, but I think the Aid Association for Lutherans case is a good one. I think that one really sets the standard of review in a situation like this. And it basically equates, in an ultra vires case, the standard of review to the situation in Chevron Step 1. Did Congress unambiguously...
That can't be right. Then the preclusion provision has zero effect.
Well, it does have significant effect, Your Honor. It precludes the review of functions exercised under the APA. And as the Dart case made clear, ultra vires claims do not fall within that. And in fact, things that exceed the statutory authority of the agency.
Then we're reviewing the agency's interpretation of this scheme and how the two provisions fit together exactly the same way we would be if we had APA review, which is Chevron reasonableness.
Well, the Chevron, of course, ultra vires claims predated the APA, as the Dart case held, and as the Aid Association for Lutheran case held. So I don't think that's necessarily anomalous. I do take the point that it's a narrower form of review because it's not for substantial evidence, it's not arbitrary and capricious. But I don't think, like I said, the Aid Association for Lutherans case, by its terms, makes clear that the review is essentially equivalent to Chevron Step 1. And the reason is that if Congress has spoken clearly and unambiguously to the question at issue and the agency goes a different way, that's the same thing as disregarding an unambiguous directive or violating a specific statutory command. Congress has unambiguously spoken, the agency has done something different. So I don't think it's dramatically different, if different at all, from the Chevron Step 1. But to get to your point, Judge Millett, with respect to how this operates in a ultra vires context, unfortunately, I did not cite this case in my brief. I did share a copy of it with opposing counsel, and I have copies from the court if you'd like. But it's a 2012 decision, Northern Air Cargo, the United States Postal Service. It's at 674 F3rd 852. And I'm happy, as I said, happy to bring a copy up to you if you like. But in that situation, the court was faced with what I believe is a situation that is equivalent to the one we're facing here, which is that the agency never grappled with the statutory language. That this was an ultra vires claim against the agency outside of the APA, where APA review was precluded. And what the court said was where the agency had made no attempt to parse or reconcile the statutory language, in that case it deemed that language ambiguous, it said you can only uphold the agency's action on the basis of a contemporaneous justification by the agency itself, not a post hoc explanation. So it both rejected the application of Chevron deference in that case and in fact found that the action could not be upheld. It ultimately remanded the case to the agency in that circumstance. So I think that is the sort of ultra vires review that we suggest would apply here. It's if the court were to find the language ambiguous, then it would not simply uphold what the agency did, but would either parse the language itself or remand to the agency ultimately at the end of the litigation in this case. Now, of course,
counsel, I think you make a good argument on the ratification, but I wonder if your case turns on the standard of review, then what do you do with our decision in Dart? Because we acknowledge, do we not elsewhere, that ultra vires review in these postal cases is a little different.
That might be right, Your Honor. And again, I take the point that this court's case law has acknowledged that ultra vires review is a narrower form of review. But again, I would point you to Aid Association for Lutherans, which I think points in the right direction. On the question of whether or not the agency
yes, I understand that, but what about our Dart decision? Weren't we fairly clear there? Or help me distinguish it.
Well, I think what the DART decision said, and it's actually an analogous case because it was decided with respect to the Export Administration Act, which is the predecessor to the Reform Act. In that case, the court confirmed that ultra vires review is available, and it found, in fact, in that case, that there was a clear violation of the statute. And the reason why it found a clear violation of the statute was, I believe, the statute had said that the agency may affirm, modify, or vacate, but the agency reversed.
Well, what would you do then with the statute here and the specific provisions in, what is it, 50 USC 4811 subpart or number 2?
Yeah, well, let me, if I may, I think it would be helpful if I talk briefly about 4813A and the language that provision uses and why we think this does create a clear and unambiguous directive to the agency to do a certain action, and the agency has flaunted.
So in
that
other
action.
words, you think that basically qualifies the authority that was delegated under?
Well, it does, Your Honor. In 4813A2, that's the provision that we've been focusing on.
Right.
It tells the agency to establish and maintain a list pursuant to a certain policy. Those are the 5 most egregious national security violations. I take the point that human rights is also an egregious violation, but Congress is the one that gets to choose the policy. Section A2 is what we focused on. If you look at A1, it also requires the agency to establish and maintain a list, but not pursuant to any particular subsection. By the way, this is at addendum 5 to our brief, if you want to look. So it says A1, establish and maintain a list of items without saying pursuant to a certain policy. It's just establish and maintain a list.
Which supports the more than one list theory.
It does, Your Honor.
Right.
It supports the more than one list.
But 4812 is crystal clear that they have to carry out the policies set forth in paragraphs 1 through 10.
In
4811. Oh, I'm sorry, there's too many numbers here. 4812, A and B both authorize and require the agency to carry out the policies articulated in 4811, 1 through 10. I get that your point in 4813 references 4011 2A, but 4812 A and certainly B require full enforcement of everything in that 1 to 10 list, which includes human rights violations.
Right.
So you're saying that's done under 4813A1 rather than 4813A2?
Well, not necessarily, Your Honor. 4812, I think in particular, is a delegation of authority to the president. They did not rely on the 4812 authority. They relied on the 4813 authority here. And so I think that, so again, whether or not the agency has the power.
Well, the 4812 is part of what they do, and is it not? Because it includes the explosive devices, missiles, chemicals, biological weapons, nuclear projects, foreign military intelligence, and all. I
guess I'm looking. Are you looking at 4811-2?
Oh, 4812A. Yeah.
Because
it's not exactly identical. It's just I'm not quite understanding for your, even if we call it a Chevron step 1 argument, how it's so crystal clear that the lists must be separate. There's supposed to be a list, even under your theory in 4813A1, that enforces everything else. And you want to say 4813A2, that has to be a freestanding list.
Well,
is that what the argument comes down to?
Well, I think it does not necessarily come down to that argument, but I will support it in this respect. Again, the entity list is a list that long predated, has a history and existence that long predated the Reform Act. And we assume that when Congress enacts statutes like this, it does so against the backdrop. I don't think there's any dispute that 4813A2 is the authority for the entity list in this particular case, which was a discrete and pre-existing list. And so that's response page 25 in the government's brief. It says that is the authority for the entity.
We're in an ultra vires posture and a preliminary injunction posture at the same time. And if there's no dispute that they get to just as vigorously enforce and through the same mechanisms enforce those who engage in human rights violations that impede foreign policy, and they get to do it by having a list, then I guess that we keep coming back down to whether there could be, your argument is it can't, well, whatever list it is, it can't be this 4813A2 list. It has to be a separate list. That's the Chevron step one under your theory, or Eldraviri's plain on the absolutely plain and clear violation of law that we would have to find.
Well,
there's nothing ambiguous in your view about whether it has to be one or two lists.
I don't think it's ambiguous, Your Honor. It says establish and maintain a list. There are other provisions in the statute that provide for additional lists. And so they might have authority to do different things.
It doesn't say an additional list. It says have a list for this, have a list for that.
Well, again, I think—
Tell my husband, have a list for groceries and have a list for errands. If he puts them on a single list, I'm content as long as he gets them all done.
Well, but that is obviously what you can tell your son is different from what you can tell what the government tells agencies, which are creatures of statute. And again, I think if you look at the API case and the Ethel Corp case, both of them are very similar in the sense that Congress didn't say, do this, but don't do this. It just gave a specific directive to the agency. And this court held on multiple occasions in those cases and many others that when it does so, the agency is supposed to listen to that directive, and it may not create a list that includes other things. It could separately do that.
For purposes of irreparable, sorry, finish your sentence. Go ahead.
It didn't purport to do that.
Okay.
Sorry.
Go ahead, finish your thought.
Well, I would guess the other thing I would point to, Your Honor, which I think shows why this is clear and unambiguous, is that both A3 and A5 use the word including, which I think is notably missing from A2. Both of them say prohibit unauthorized exports, including to foreign persons in the United States or outside the United States. A5 says require licenses of controlled items, including to, under these certain conditions. I think that language is notably absent from the very next door provision, A2, which does not use that including language. So I think that cuts against the reading that this is simply a minimum. They can create a list with that and anything else they want. I think you can't read that.
Okay.
I just think that the clear way to read that language is establish a list that includes the 5 most serious national security threats.
Okay, I don't think it said most serious. It just said for that list. If we assume you're right that the misstep here was that they combined 2 lists rather than having a separate one. And so then the question would be, they can list you and they can impose your client the exact same sanctions. And I can't imagine it's good for business to be on a human rights abuser list as opposed to this list. How would the irreparable injury be any different?
Well, Your Honor, I think there's a serious question about whether the government would relist us in that circumstance. If you were to find that this language is clear and unambiguous, the way to read this is Congress said, create a list with these policies, and they added a 6th unenumerated one, then I think there's a serious question about whether on remand the government would re-add us to a list.
I'm just asking, let me try the question again. Would your injuries, your asserted irreparable injuries, be any less or any less irreparable or just any less injurious if they had done what you're saying the statute says and had created a separate list?
I do think arguably yes, Your Honor, because this is a list with thousands of entities on it, many of them for producing military equipment for weapons of mass destruction and terrorism. We have been lumped in with nuclear proliferation.
Okay, but all the bans, I thought the economic consequences and bans on business and exports and all of these types of things are going to be exactly the same. And the fact that you're on that you would be on a bad entity list from the U.S. government, and they could issue the same red flag warnings to people. You still think, it wasn't clear to me from your irreparable injury arguments that you'd be any better off.
Well, again,
maybe you wouldn't like the company better. I'm not sure. Or you like the company better? This
goes to the central point that I've been trying to explain, which is that the entity list is a pre-existing list. It has this history. It has thousands of entities on it with, nuclear weapons proliferation.
Yeah, but you'd be the only one on this new human rights abuser list. That's better.
Well, I think there's a significant question whether they do that, Your Honor, and I can't speak about it in open court because it's under seal, but the condition that the government imposed makes, in my mind, very unlikely that on remand, the government would try to re-add us to a list. In our view, the government has no evidence, which is consistent with all the evidence that is in the record with respect to the odious allegations they've leveled against us, with regard to their
Does injury count as
accusations.
Am I interrupting you? Does injury count as irreparable? If the party concedes, it could be subject to those exact same injuries as long as the government just dotted its I's and crossed its T's properly?
Well, I think we're here on a preliminary injunction posture. I mean, first of all, I would not concede that's the exact same injury. I think it would be a different sort of injury. But I also think that the fear of some future hypothetical injury, which is not actually the action they took, they did not justify what they did based on adding us to some combined list of both the entity list plus the human rights abuser list. So the hypothetical future injury, I think, is just not before the court. That could be adjudicated in a future preliminary injunction action. On that point, Your Honor, I think under the sliding scale approach this court has employed and has not abrogated, we need to show a serious.
Do you have to have the sliding scale to win?
No, I don't think so. I think we have the clear and unambiguous reading. But I think at a minimum, we've shown there's a serious legal question on the merits. I mean, again, it's hard to read that language in A2 as doing anything other than create a list pursuant to these policies and don't add your own, particularly knowing that Congress legislates against the backdrop of both pre-existing case law and, its knowledge of the list, and would therefore be aware of how this court would interpret a clear and specific statutory directive, especially when you compare that language to the surrounding subsections, which does not impose the same limitation on the agency's authority.
Your interpretive theory, it rests on a very strong conception of expressio unias. You have a specific provision which says create a list pursuant to the following considerations, and there's an additional consideration, and the government is relying on some more general authority. And you say they just can't do that, period, full stop. But we have a lot of cases in the Chevron context which say that expressio unias is a feeble helper in the ad law context. And you have cases where the government's won in this kind of situation, but I'm sure there are a lot of cases on the feeble helper rationale where you've won. There are a lot of cases where the government wins on the ground that the expressio unias inference is not strong enough to preclude the government from resorting to the more general authority. So how do you reconcile? I mean, if it's a feeble helper and a debatable point, isn't that fatal on in a non-statutory review context?
I don't think so, Your Honor. I don't, for several reasons. One of them is that it's a feeble helper, the court has said in a few contexts, but it's also said it depends on the statutory language in the context. So, for example, the case that my friend on the other side cites, the Farrell v. Blinken case, it was a feeble helper in that case because the authority that was granted to the agency, they weren't going to impose a limitation found in other subsections, but not in that one. That's very different from what we have here, where we're pointing to a list that Congress has directed pursuant to 5 specific and only 5 specific goals. So I think that shows that it depends on the context. I think we also have the specific and general canon, Your Honor, which I think is equally strong. If not stronger.
These are all variations on the same theme, right?
Agreed, Your Honor.
Specific, general, superfluity, right? Just depends on how you think of the interaction between A2 and A16.
Right. And I think this court in very strong terms, and I think the two of the best cases we've cited are the API case and the Ethelcorp case. In the API case, that Congress directed the agency to regulate gasoline to create the greatest reduction in emissions of ozone-forming volatile compounds, as well as certain subordinate goals such as energy requirements. What the EPA did was create a rule that required certain use of ethanol, even though that might not reduce emissions forming volatile compounds, and it relied on its general authority. It said, under both the EPA's general grant, the Clean Air Act's general grant of authority, which allows us to promulgate rules necessary to carry out the functions of this chapter, as well as a specific provision granting them regulatory authority in that section. They said, well, we have the authority to, focus on other goals besides just emissions reduction, or in addition to emissions reduction.
Okay.
It's not a floor, or it's not a ceiling, it's a floor, they said. And this court very clearly, EPA cannot rely on its general authority to make rules necessary to carry out its functions, given the specific statutory directive that defined the relevant functions. And that's the same situation here. When Congress has been as clear as it is, and if you look at it in context too, there's 15 different actions Congress has required the agency to carry out. And then A16 says, and any other action that you want to carry out. It's very detailed about what it wanted to do. And in some of those sections, it said, do it pursuant to a specific policy. And some of them, it said, do it to all the policies in there. But I think when you read that language in context, it does become clear that this is not a situation where we're looking at other statutes, other provisions elsewhere to try to gin up a expressio unias argument. It's clear from the very face of the language that Congress used.
Just one more question on interpretive principles. Another one which might be relevant here, government, I don't think invoked this, and I'm not sure why, but there is a presumption that when statutes govern the president's exercise of foreign policy, they are, in cases of ambiguity, they are construed not to constrain the president's discretion. Wouldn't that have a lot of sway here when we're talking about how to manage export restrictions on human rights abusers abroad?
Well, I don't think so, Your Honor. And I think the reason is really the legislative history in this case. And by that, I mean the way
the statutory history.
Statutory history, exactly. The way the Reform Act came into being. Originally, these sorts of regulations were under the Export Administration Act. After that, the authority in that statute lapsed. The president continued the export control regulations under the authority of IEPA, which, as you know, is a very broad executive authority to deal with national security and foreign policy. In 2018, Congress overhauled that regime by placing these regulations on a new statutory footing. And when it did so, it imposed certain restrictions in certain places. It gave specific directives about what it wanted the agency to do on a going forward basis. And the agency's response to that with respect to the entity list was to completely ignore it. It continued to do business as usual. It simply continued the exact same trajectory it had already done, where it was expanding the grounds for the entity list. It has never engaged outside of this litigation. Certainly the government has not pointed to anything. It has never engaged outside of this litigation with whether or not there is any limitation imposed on that at all. The floor or minimum theory that the government advances is a litigation theory. It is not one that the agency has undertaken at any time prior to this case. Happy to answer any other questions or reserve the balance of my time. Thank you.
May it please the court, Daniel Aguilar for the federal defendants. So Congress enacted the Export Control Reform Act here to enhance the executive's ability to use export controls to protect national security and foreign policy. And it explicitly ratified all previous actions that the executive branch had taken to further that. That includes the Federal Register notices we cited explaining that we can add entities to the entity list when they act contrary to our foreign policy interests, including violation of human rights. And it included the several designations that we made of Russian entities for a variety of reasons, including acting contrary to our foreign policy interests in taking Crimea from Ukraine, interfering in the United States elections, et cetera.
Sorry, had there been entities, I should know this and I'm just blanking, had there been entities added to the list just for human rights violations prior to the amendment?
No, Your Honor, not specifically for human rights. The Reform Act, what Congress did was it provided us with a comprehensive sentence of authority to safeguard the country, but then, contrary to Commerce Department's and the executive branch's longstanding understanding of its own authority, had said you cannot add entities to the entity list.
You have rules, orders, and determinations, and determinations are interpretive positions in the air.
Yeah, and quoting from 50 USC 4826A, and it also says, or other forms of administrative action. I mean, Congress here was pretty broad in saying that we are ratifying and confirming the executive branch's understanding of its own authority.
Though you might read this to require agency action as opposed to just an expressed view. I'm not sure.
Well, and that's why, Your Honor, we were also pointing to the actions where we had listed entities acting contrary to our foreign policy interests. Excuse me, and when Russia invaded Crimea and when Russia took actions that were contrary for interests in spreading.
Congress didn't have any experience, concrete experience that it would have been aware of someone being listed just for human rights, asserted human rights violations.
I'm sorry, Your Honor.
Congress didn't have, you had, I thought you said, maybe clarify if I misunderstood your answer. Prior to the statute being enacted, the Commerce hadn't, or the federal government had not listed someone just for human rights violations.
No, Your Honor. We took that action here. But we had expressed our understanding that this is the authority that we generally have.
And you had expressed that where?
We had expressed that in the Federal Register notices. I believe that we said that at the beginning of our brief, starting in about 2012.
Okay.
And then we had consent.
But it hadn't yet been applied, so rubber had never met the road in this regard. I
suppose it's true, Your Honor, but I think, again.
And since, finish your sentence. I'm sorry.
Oh, sure. But again, I think as you noted, we're here in a particular strange circumstance. This isn't here on APA review about trying to parse out the particular delineations of the articulated authority here. We're here on non-statutory ultra vires review, where opposing counsel is seeking a preliminary injunction to take an entity off of the entity list, to not subject them to our export controls when the United States has made a determination that they're acting contrary to our foreign policy interests.
Since so we talked about before the 2018 Act, since the 2018 Act, up to this listing, I know that there were, 10 other entities that were listed with them, but between 2018 and this listing, had someone who engaged in human rights violations been listed, or asserted human rights violations been listed solely on just for that?
Contemporaneously, we listed other entities.
Not contemporaneously, but I know that there were 11.
You're talking about between 2018 and this listing.
And this listing, yes. I'm sorry, I wasn't clear. So once the statute's enacted, since the enactment of the statute in 2018, whatever date that was, and the listing they are challenging, at least for their name now, in that interval, were there any human rights abuse listed?
Not that I'm aware of.
So this is the first time in history of these types of export controls that someone has been put on the entity list for asserted human rights violations. Alone.
It was about a 2-year span in between those. So yes, after 2 years after the act, this was
just never happened until now.
No, but again, it's not limited to human rights violations, right? As I understand their theory, it is that we are limited in placing entities onto the entity list solely for what's described in 4811-2A. So if you take, for example, the policy interests that Congress identified in 2B, if somebody threatens the qualitative military superiority of the United States, we cannot place them on the entity list for that reason. Or if you look at 2E, our ability to sustain and fulfill international obligations, we cannot place an entity on the entity list if they threaten or act contrary to our ability to do that. We can't use the export controls against them for that reason.
You can have as many lists as you want. You could have the entity list, and you could have the entity part B list, entity prime list, and list everybody there. I don't understand how that would impair. I mean, at least for me, at this level of review that we're doing, we're not digging in, as you rightly pointed out, any more deeply than ultra vires review. It seems to me that you've got a pretty sound argument that you could have other lists, but this is the worst of the worst list, I guess is what they would say. This is the notorious list. So it's not that they're tying your hands. It's just Congress said, look, here are the 5 things that, in fact, they took the time to say these are the 5. I'm I'm putting words in Congress's mouth here, but it would seem to be worst of the worst, and that they are existential threats to the United States, those types of violations. That's that list. It's like the FBI, top 10 most wanted. Doesn't mean we don't want everyone else, but these are the top 10. And then you can have your other list, and you can label it however you want. You can do every single thing to punish them that you're doing here, but it's just not how this list has been used. Certainly at the time Congress acted, they weren't thinking of this as a human rights list. If they were thinking of it as a human rights abuse list, why would they say for purposes of 2A or 811 2A?
So getting to that, I think that's the fundamental difference between our respective statutory constructions. We read this as Congress saying, so for example, in 4813A, it says create a list of items for control. So that includes weapons, it includes various types of technology, gases, et cetera. And so Congress said, look, we don't know particularly what kinds of items should be on this list. Please use your discretion. For the next subsection 2, it then says, create an entity list, or we know that you already have one, and be sure at a minimum that it needs to contain these particular types of activities, terrorism.
It didn't say at a minimum, that's your reading, but yes.
I'm sorry, Your Honor.
Congress said have a list that includes these 5.
Yes, it says you need to have a list. It needs to, if you determine that anyone.
You must have a list that includes these 5.
Yes. And then it's not limiting that authority. It's not saying you cannot have other reasons to use the export controls to require a license before doing this. And again, the entity list is a creature of regulation. It's a creature of longstanding regulation. Congress didn't specify in 4813 that there is such a thing called the entity list, and it must be constricted only to these things. Indeed, in subsection 16 of that, right, what Congress says is, and you shall undertake any other action necessary to safeguard our policy objectives that we've identified that is not otherwise prohibited. And that's a very broad grant of authority. And what Congress said in the purposes section of the Reform Act, right, in 4811, is it says these are the purposes for the export control. And then the last section there, I believe it's paragraph 11, says you can't go beyond this. This is the universe of policy objectives that we have given you, and you need to use the export controls for these purposes. But what it didn't say is, and we care about our military superiority, we care about our international obligations, and we care about our foreign policy, clearly. But you can't place people on the entity list for those reasons. And Judge Millett, as you're pointing out, I think it only underscores the correctness of our position that we can create multiple lists. But that's a level of formalism, I think, that sort of blinks at reality. That because you might have one combined list as opposed to 2 or 3 or 17 different other lists, and somehow then Congress has prohibited and barred the agency from acting here in such a clear and mandatory manner that it's a patent violation of law for the executive branch to be concerned about foreign policy and to place entities on this list when they act contrary to our foreign policy and national security interests.
In the wake of Aid Association for Lutherans, that ultra vires standard that you just articulated is the one that we should apply here, as opposed to their argument that there's a bit softer one in this context?
Well, as I note, Your Honor, this question of the exact scope of ultra vires review under the Export Control Reform Act is also being considered by this court in FedEx Corporation versus Department of Commerce. I believe it was submitted November 5th of last year. So that's going to be decided by this court very likely in that case as well. But what I would point the court to is its decision in Griffith versus FLRA, where it laid out the ultra vires standard of review, and it said an error of fact of law is insufficient. We have said that review may be had only when the agency's error is patently a misconstruction of the act, or when the agency has disregarded specific and unambiguous statutory directive, garden variety errors of law or fact are not enough. And that seems to me to be the standard of review here, particularly.
So how are you distinguishing the Lutheran Aid Association for Lutheran case?
I think so. As I understand Aid Association for Lutherans, it was there as well that it was a clear violation of the statute. And so this court has used some different formulations of it, whether it's a patent misconstruction or a clear misconstruction, as I think Dart says, but it's a clear and unambiguous directive that leaves no determination to the contrary. And here, I think, one, we're just correct on statutory interpretation at bottom, but 2, even if you think, well, maybe on balance, there's a better construction, maybe on balance, there's some more articulation here, I mean, that's sort of the fine-grained determinations that you would usually be making on Administrative Procedure Act review under Section 706 of the Administrative Procedure Act. But what we know what Congress said here under the Export Control Reform Act is that does not apply. We do not want Administrative Procedure Act review of these sorts of determinations. And Congress specifically cited the standards of review of the APA. It cited Section 706 as part of the prohibition of APA review. It said that does not apply to these kind of determinations. So necessarily it has to be a higher standard, because otherwise I think you'd see a lot of entities, as you're saying, who are on a determination that they present a substantial threat to the interests of the country, raising non-statutory ultra vires arguments that, well, either you didn't have the specific and articulable facts to put me on the entity list, or actually I'm on here for this statutory reason and the government's reason under 2A is pretextual, or any other number of challenges to the executive branch's determination here about what's necessary to protect our national security and foreign policy. And I think that that's exactly what Congress was trying to stop at the outset in enacting that bar on APA review. It said, we will allow for APA review when there is a particular enforcement proceeding, where you've had an administrative record. That's not an issue in this case, where the agency has had an opportunity to respond to particular challenges. But this is a rare bird, and this is not the kind of challenge that should be allowed to, again, obtain a preliminary injunction, an extraordinary form of relief against the executive branch's considered determination here about what is in our foreign policy interests.
Well, let me ask you, in terms of your rare bird argument, the argument here is that, there have been a lot of human rights violations asserted either by the president or the agency, but not in regard to this particular list. That is the list at issue. And why isn't that some indication that a couple of things? Either Congress was not as clear as it might have been, or the agency itself in the interim offered no interpretive language, and this rare bird comes along 25 years ago and lists this entity for human rights violations. So we do, if you can't find anything where Congress was explicit, then you look at the agency's contemporaneous interpretation. We don't have that here.
So I think responding to those points generally, we don't. So what the agency has consistently said before this is that foreign policy reasons acting contrary to our foreign policy interests and human rights abuses are reasons that we can place somebody on the entity list. And we agree.
What I'm getting at is this is such a serious action by government. And that's the argument here. And the agency has never interpreted its authority to allow it to do what it did. And it doesn't point to evidence that Congress contemplated this. So I understand one argument that says, well, looking at DART, the standard of review here is much higher. But we have all these other cases that suggest not necessarily that high, that if you can show Congress clearly thought these 5 purposes were critical. And while the agency can take this additional action, it never has before. It hasn't, despite the world full of claimed human rights abuses, it hasn't exercised this authority before. So that's the rare bird coming back at you.
Well, I think, Your Honor, that's because, and it's consistent with our understanding of the statute, is that this is a discretionary listing that the executive branch is able to make, right? As we've explained under 4813A2, Congress has mandated the essential limits of what this must contain at a minimum. If anybody is conducting acts of terrorism or threatening our military capabilities, they must be placed on this list. But that's far from saying there is a bar from placing entities on the entity list for any other reason. And I think we
understand that, but Congress didn't, you haven't cited any indication that Congress actually contemplated having this other list. I mean, Judge Millett has been through with petitioner or appellant's counsel other provisions, but I just wonder to what extent on ultra-virus review we can fill in all these gaps.
I don't think that you necessarily need to fill in any of the gaps. I think and I'm sorry, I hadn't read the case that opposing counsel had cited to me yesterday very closely, but as I understood that case to be on ultra-virus review, it said, look, it doesn't necessarily, we don't need to come to a conclusion one way or the other about what the statute means. So long as readings are plausible or colorable here, that's sufficient to defeat ultra-virus review. I believe the opponents had gotten an injunction against the government's action, and then this court said, no, you don't get that injunction. This has to go back for further proceedings. So I think what ultra-virus review requires is if you have, an open and shut case, which is what this court considered DART to be, maybe that is sufficient. But I think as you're looking to these cases that go through these sort of exercises in statutory construction, I'd point the court to Adirondack Medical Center, where this court was considering exactly what the agency could do. And it said there, the expressio unius canon is a feeble helper, where we presume Congress to have granted the agency reasonable discretion. And that canon saying like, well, maybe because we granted you something specifically, we've prohibited the rest, that can be countervailed by a broad grant of authority contained within the same statutory scheme. And I think that that's what we have here. If you look to what Congress granted the president authority to do in 4812B7, it said the president can personally just create a list of entities that are threatening our national security and foreign policy without limitation. And then 4813 is directing the rest of the executive branch to assist the president in carrying out those, and reserves a broad grant of authority saying that the executive branch, Commerce Department, state, treasury, etc., can take any other action that is not otherwise prohibited. And I think the key difference here is they're saying because Congress specified a grant of authority, it is necessarily prohibiting the rest. And that's at least debatable. And I think I still haven't heard, and maybe there is one, but I'm not aware of it. I haven't heard a reason why Congress would pass the Control Reform Act, grant the executive the authority to use these export controls, ratify all previous action, but nevertheless then, for the first time, severely constrain our ability to add entities to the entity list for only 5 reasons. Even if an entity is threatening our military superiority, we can't add them to that reason, even if it's harming our international obligations. And that
all I'm getting at is under the 5 reasons that are specified, there are ways to write violations that are human rights violations that come within the 5, but that's not what happened here. That's all I'm trying to get at.
I agree, Your Honor. I agree it's discretionary. It's not a mandated listing. And there may be other cases where those reasons would overlap and that Congress didn't write it that way. But the fact that Congress could have written it another way does not necessarily mean that Congress prohibited and tied the executive branch's hands in this instance. And I think that the concession that we could place entities on an ultra-formalistic separate piece of paper for the exact same substantive export controls and the exact same reasons under the exact same regulations confirms the understanding here that we are not acting so far outside our statutory authority as to warrant non-statutory ultra vires review.
So you understand counsel's concession to be that broad?
That's what the district court understood it as well, Your Honor, at Joint Appendix page 178, where it quoted the transcript from the preliminary injunction hearing, as I understood opposing counsel.
I know, but that's in a broader context. Here, we're just dealing with the ultra vires, and I just want to be clear about that. Because
that's what I understand there.
Now we're into this express statement requirement by Congress. The Supreme Court's emphasized that in so many different contexts. And I just wonder here, that's what I understand is happening. That's part of the argument. But you're saying absent a plain statement by Congress, you cannot do this, or I suppose you can do this, regardless of what we may have said before.
I think that's consistent with what this court has said before, and I'd point to DART there as well. What this court said is, in DART, ultra vires review is narrow and must not simply involve—
no question about that, all right? And I suppose you would read our decisions then to say, even where there is a serious question, and you're just saying there's no serious question.
So here we are saying, one, there's no serious question. If this case were here on Administrative Procedure Act review, we wouldn't prevail.
No, I understand that, but I'm talking about ultra vires.
Sure, and on ultra vires, as I understand this court suggests, ultra vires review is possible where there is a, quote, clear and mandatory statutory directive that was nevertheless violated. That's from DART at page 231.
No, I understand, but as I've said, and I thought your earlier answer to my question about DART said, well, but there are these other views, and then you went on to talk about other views of ultra vires review, narrow though it be.
Yes, Your Honor, I think those are all, I don't necessarily see a difference between them. I think that they're all consistent with each other in different formulations. And I don't necessarily know that this court needs to get into a reticulated examination of them, but if you do, I think the patently and misconstruction of the Act from Griffith it seems like that's the appropriate standard.
So one other question. In this particular case, given what's happened subsequently, there is no remedy, as I understand the position. Is that correct?
Do you mean the preliminary injunction remedy or the delisting from the entity list?
I mean, in terms of what the agency did subsequently in finding that it would have reached a different conclusion provided these two conditions are met. And one of those conditions, we're told, cannot be met.
Right. I think that fact and the reasons for it only underscore why plaintiffs are not entitled to a preliminary injunction of the executive branch's determination here.
Can I ask, so that condition that's under seal might impact your eagerness to pursue this? Now, don't blurt out a sealed fact in open court. Just give me a yes or no answer to the question. Are there any recently changed circumstances that impact that condition one way or the other?
I am not aware of any, Your Honor.
Okay.
I'm happy to answer further questions, but we'd ask you to affirm the denial of the preliminary injunction.
Thank you, Your Honor. I'd like to make 3 points unless the court has any questions. First of all, just briefly on the standard of review, I don't think there's any dispute that in this case, ultra vires review is available to us. That's what the DART case says. I understand my friend on the other side mentions the Griffith standard, error of fact of law even is insufficient. This court has also used words like extreme, Hail Mary, patent. I think the best way to reconcile that sort of language and those descriptions of the ultra vires standard with the Aid Association for Lutheran case, which is what we think sets forth the proper standard here, is in those cases there was a review provision that precluded review generally, whereas here there's no dispute that ultra vires non-statutory review, which predates the APA, is available to us. And I think that the Northern Air Cargo case, which is the one I mentioned, as well as the Aid Association and the DART case, all found that the plaintiff prevailed on that non-statutory ultra vires review. It is not an insurmountable barrier by any means. Briefly on that Northern Air Cargo case, which is the one I cited today, what happened there is the court actually found ambiguity and said we cannot affirm the government's interpretation given that ambiguity because they failed to provide one during the provision. So it was not a case where plaintiff lost. In fact, the government lost in that case. The second point I would make briefly is that, I think it's entirely sensible that Congress wanted a list of the worst of the worst. And that's what that language reflects, to Judge Millett's points, the 10 most wanted. And it would dilute that list to add entities for reasons other than those lists. Not only are those the worst of the worst, it was also the traditional contents of the list. It was done pursuant to that specific policy. And I think it's strange to imagine that given the statutory history, Congress would have enacted a law that specified that the agency continued to do exactly what it's been doing and what the list has always done. I think when counsel was describing that, he even used the word including, make a list that includes these things. But of course, that is not what that language says. It pointedly does not use the word including. Now, of course, Congress can change its mind. And in fact, there's language that is circulating, has been passed by both houses now, that would actually literally add a Romanet 6 to the list of 5, 6 being serious human rights abuses. In that situation, going forward, there should be little doubt that they would have the authority to add entities to the entity list for that purpose. But I think that strongly suggests that they don't.
Does that legislation require the inclusion?
Literally all it does is 4811(2)A has the 5.
So it's required to be included.
6.
Right.
Well, we'd say it gives the agency the authority to add entities to the list for that purpose.
Would it allow them to say, yeah, but we don't want to?
No.
Right. It would be required for them to list.
Right. That will be the specific directive.
Right.
And again, as the API case and others make clear, Congress does not need to say, do this, but don't do that in order to make its intentions clear. It can set both the policy and the means of effectuating that policy. The final point is, I think Your Honor Judge Millett asked about whether this is formalistic. In addition to the points I made, which is that this is the worst of the worst list, I would also point out that there are special procedures with the entity list that would not necessarily be found in some future list. Such as you need a unanimous vote of an interagency committee to be removed from the list. That's part of what explains the current predicament that we are in. We're stuck here because of this problem. We've been conditionally removed, but are in sort of limbo. And the irony of all this is that this company is an ethical company. It prides itself on its ethical company. It's a founding member of the United Nations Global Compact, which is a sustainability and human rights company. It's been part of this region for a long time. It pays farmers directly. It pays double or triple the minimum wage. It's insult upon injury to be added to this list of the worst and have really no way of removing. So I would urge this court to find at least a serious legal question on the merits and either enter the injunction or remand with instructions for the court to consider all of the preliminary injunction factors. Thank you.
Thank you, counsel. We'll take the case under advisement.